Jordan, one regular asks, if I already have a B1, B2 visa before U.S. citizen submitted I-130, can I travel to the U.S. while an I-130 is pending through consular processing? So that's a question I get a lot. So essentially this person already has a tourist visa, they have a marriage case pending, the form I-130 to prove the relationship is real. Once that's approved, they're going to set up an embassy appointment to get their green card. But this process takes like 2+ years right now. So in the meantime, the foreign person has a tourist visa, wants to come visit the United States, wants to come visit their spouse in the United States. Is that possible? Technically it is possible, but the issue is when you try to enter the United States, you have to go through a port of entry, CBP, the Customs Border Protection is there. And they have to review and make a decision. Is this person really entering the United States to become a tourist, to temporarily hang out and not work and leave? Or are they actually entering as an excuse to be saying I'm a tourist, but really after they enter, they're going to file for a green card through adjustment of status instead of consular processing, because it's preferred to adjust status to be with your spouse in some cases. And so they're going to make a determination. So can you do it? Yeah, people do it all the time. But you know, you just might have bad luck, or the officer, you know, might not believe you that you're coming temporarily. There's a factors, and if they remove you from the United States, now if they give you what's called voluntary withdrawal, they say, listen, get back on a plane, go home, we'll call it even. That's not too bad. It's annoying. You have to, you know, get on a plane, go back after a long flight. But if they think you're lying and they give you expedited removal, which is not that often, but it does happen, then you're going to be in a really bad situation, because expedited removal has automatic bans, and you have the ban on a re-entry. You have to get a waiver. You potentially maybe accused of fraud, so you might need a fraud waiver. In a marriage case, at least waivers are possible, but it gets really messy from there. So typically the answer immigration lawyers always give to their clients is no, don't do that. And that was my answer for half a decade or more. But so many of my clients didn't listen to me and just came on tourist visas that I saw like, well, it's not that bad. It depends on the facts. So, you know, if you come to the United States, but you have work back home, you have a job at home, and you have a return ticket, and the officer feels like, you know, you're being honest, you're going to just be here temporarily, hang out and go and finish the case out, consular processing later, it could be okay. But the thing is, it's up to the discretion of a CBP officer. And we never know who you're going to get. You might get somebody who wants to be difficult. Most of the time, they're not going to be like that, especially if you're honest. So it's a determination you have to make, how much risk you want to undertake, how much risk you want to take on. But it's up to you. Again, immigration lawyers typically say don't do it, but you know, you got to give it a shot, do what you got to do. Thank you for watching this educational program. To get the latest videos, click the subscribe button and the notification bell icon. Also, help us help the immigrant community by liking this video and sharing it with your family and friends. You can also find us on other social media sites like Instagram, Facebook, TikTok, LinkedIn, and Twitter, where you find the latest updates on immigration news, policy changes, and tips. Be safe and God bless. See you soon.